And good afternoon, good evening, good morning. It's great to have you here. My name is Janice Kaminer-Resnick, and I'm delighted to welcome you on behalf of myself, former Congressman Mel Levine, and former Los Angeles County Supervisor Xavier Oslovsky. That is our America at a Crossroads leadership team. A special welcome to tonight's guest, the great Dean Erwin Chemerinsky. We're all anxious to hear your insights and analysis about the state of our Constitution and our democracy. And of course, welcome as well to tonight's great moderator, Warren Olney. This weekend, we begin the celebration of Hanukkah, a holiday which recalls events which occurred more than 2,000 years ago. At that time, the Greek Empire sought to cancel Jewish religious practices and customs to force the Jewish community to renounce Judaism and to conform to Greek culture. In response, ordinary Jewish citizens rose up against the powerful empire and fought to reclaim the right to assert their identity, the right to live according to their values, and the right to teach their children those values. Hanukkah commemorates the improbable military victory of the Maccabees, a small band of Jewish resistors over a mighty empire. And the holiday represents the enduring human fight to protect dignity, conscience, and self-determination. In this sense, Hanukkah is profoundly linked to our struggle today to preserve our democracy. Hanukkah can remind us that democratic values are never guaranteed. They must be protected when threatened by forces that seek domination. The ancient Jews' refusal to accept autocratic decrees mirror our own responsibility to defend pluralism, minority rights, freedom of the press, and the rule of law. The candles we will light each night of Hanukkah can push back darkness and be a reminder that it is possible that advocacy based in moral clarity can outlast those who wield power unjustly. This Hanukkah, let us emulate those who stood up to the great empire. We can rededicate ourselves to stand up against intolerance and to resist erosion of freedoms. We can choose to recommit ourselves to build, or maybe I should say to rebuild, a society grounded in justice, equality, and hope. And hope. That rededication and recommitment to the pursuit of justice, equality, and hope, in our opinion, as the leaders of Judge, this program is the essential meaning of Hanukkah 2025. We wish you all a great holiday. Next week is December 17th at 5 o'clock. We will welcome former U.S. Ambassador to Russia, Michael McFaul, and global democracy scholar Larry Diamond, both of Stanford University, to discuss autocrats versus Democrats, the new global disorder. That will be our final program of 2025, so we hope you will join us. I can't believe we're already at the end of 2025. Of course, the following 2 weeks after that, one is Christmas Eve and one is New Year's Eve, so we will not be having programs those Wednesdays. As a final note, I want to thank our great audience for your financial support. If you haven't already had a chance to make your 2025 donation to Judge, it's not too late to do so. Just press the donate link you will find in any of our emails, and there is one coming right after this program tonight. Now, without further ado, please welcome tonight's moderator, veteran TV and radio journalist, talk show host, and news anchor, Warren Olney. Warren has received so many different awards, it would be too many to tell you about, but the most important thing in our opinion is the fact that he's so dedicated to America at a Crossroads, and he's always does a great job moderating these forums. So now, Warren, the program is yours.
Janice, thank you so much. You're very kind. And it's always a privilege and a lot of fun to talk with Erwin Chemerinsky, who's a familiar figure here on America at a Crossroads. He is one of America's leading authorities on law and the conduct of law. He's been Dean of the UC Berkeley Law School since 2017, and before that, he was the founding Dean of the Law School at UC Irvine. He appears frequently before the U.S. Supreme Court, practices elsewhere as well. He's written hundreds of articles and 20 books, more than 20 books. Most recently, No Democracy Lasts Forever, How the Constitution Threatens the United States. I hope we'll be able to make some references to that today. There's so many things that, Erwin, that call for your expertise at the moment going on that I'm very much looking forward to this conversation, and welcome back to America at a Crossroads.
Thank you. It's always wonderful to be part of America at a Crossroads, and it's always terrific to get to do an interview and a program with you.
We're talking about the U.S. Supreme Court in a moment. Of course, it's been very busy this week, and there's a lot to be said about that. But before that, The latest off of Venezuela raises some legal questions, particularly now the latest is the seizure of an oil tanker by the United States, pursuant to a lawyer, apparently a seizure warrant issued by a judge because of the ship's past activities smuggling illicit Iranian oil. Is it, this is highly unusual to say the least. Is it legal?
It certainly violates international law. International law would say, unless there's a war, there's no basis for this. And we don't have all of the facts. It may very well violate United States law as well. We've got to keep in mind this is the president engaged in piracy and taking acts of war without any semblance of a congressional authorization.
Why would he need a congressional authorization? There's nothing in the law that says he can do this?
Well, there's nothing in the law that says that he can do this. His claim would be he has the power as commander-in-chief. But the power of commander-in-chief isn't limitless. The Constitution also says Congress has the power to declare war. Take, for example, after 9/11, Congress passed the authorization for the use of military force, and it authorized the president to be able to use the military to repel al-Qaeda's aggression. There's nothing like this with regard to Venezuela. There's no reason to believe that Venezuela is engaged in any military actions against the United States. So the seizure of the tanker is an act of war, it's an act of aggression, and there's no authority for it.
The Trump administration is saying that, in fact, what Venezuela did was what the ship did was a violation excuse me, not a violation. It was inappropriate, if that's the right term. I'm not sure what term to use since you said legality doesn't apply. But it has to do with the declaration that there was terrorism involved on the part of Iran. And it has indirectly then to do with the smuggling of Iranian oil by this tanker. I'm sorry that I can't explain it as what they're saying in more clearly. But does that sound right at all to you or appropriate?
We obviously need more facts. What we see in the press sounds very attenuated. And also, what we have to keep in mind is this is in the context of a president who is making warlike noises relative to Venezuela. It started with illegally deporting individuals who were from Venezuela. This past spring, President Trump invoked a federal statute, the Alien Enemy Act of 1798, that allows for summary deportations only if we're in a declared war or facing imminent invasion. And he wanted to use this to deport 300,000 people from Venezuela. So far, the federal courts have said that's illegal. And then what we have is President Trump attacking boats that he said were involved in drug smuggling. To this point, 83 people have been killed by the American attacks. And these are extrajudicial killings that again violate international law. This is imposing the death penalty for the crime of drug trafficking without any basis in American law. And now the seizure of the tanks of Venezuela have to be seen as a part of this pattern. And the question is, why are we planning to go to war? In fact, in some ways already are at war with Venezuela.
The president says we're not at war, though, or he hasn't declared war. The Congress certainly hasn't declared war. Is that the most important thing? Would these actions be legal if, in fact, war had been declared?
Yeah. If there were a war, and we can then talk about what's sufficient in terms of a declaration of war, then there is the ability to fire at boats from an enemy. There is the ability to seize the tankers of the enemy. But without any form of declaration of war, any form of authorization, under international law, you can't seize another country's boats. You can't blow up another country's boats. And the question is, of course, how will that international law ever be enforced, if ever?
On September 2nd, there were two attacks on the same boat, one original one and then a second one that took place when there were apparently two people visible on the boats, either waving or whatever. We haven't seen those things, and they're described differently by different people. Is there a difference in the legality of the first and the second strike?
Both violate international law as extrajudicial killings. And to put this in context, all of the prior presidents for this one had a policy where we would interdict boats we suspected of drug trafficking. We would arrest the individuals. Sometimes they were guilty of it. Sometimes we were mistaken as to whether there were drugs in the boat. The problem is when we blow up the boat and kill the people, that really is the death penalty without any semblance of due process. Under international law, the extrajudicial killings are impermissible. Under United States law, there is a recent letter from the Office of Legal Counsel, Emil Bovey, who's now a federal court of appeals judge, saying that it is legal for the United States to destroy these boats. I have not, and I don't think anybody yet has seen that memo, and I'd be fascinated to see the reasoning. But even if you could argue under United States law, the attack on the boats was permissible, the second attack was clearly impermissible. These were individuals who were hanging on to what was left of the boat. They posed no threat to anyone, and there is the duty then to try to rescue them. It violates the law to kill them.
What if they were signaling to their confreres, or if they were attempting to get the boat back in business? Does that make a difference?
It does, and that's the argument that the Trump administration has made.
Yeah.
But at least on the basis of the videos that were released to Congress last week, it doesn't appear that they were in any way signaling anybody, or that they had the phones to signal. In fact, the military officials themselves said that at this point in time, they were just hanging on to the wreckage. They weren't signaling to anybody or trying to steer the boat to the United States.
Is the second attack then likely to be, or could it be considered murder?
Sure, it could be. Now, keep in mind that the president can't be criminally prosecuted for anything that he does in carrying out the official duties of office. That's what the Supreme Court said in Trump versus United States on July 1st, 2024. But the military officials who launched that second attack could be prosecuted for homicide.
What about the Secretary of Defense, Secretary of War, as he calls himself?
What we'll need to know is what was the role of the Secretary of War? Did Pete Hegseth order that second strike, or was it done without his knowledge? We've had conflicting reports in the press about that.
So obviously a lot of things to be determined that we don't know, but you're pretty persuaded at the moment that there's nothing illegal about any of this.
And I think that's right. And again, I want to focus on international law is so clear that what we've done is illegal and impermissible. When we talk about United States law, it then becomes harder questions, and we have to be much more careful about what we're talking about.
Could we be taken to a court in violation of international law?
Sure, there are international courts. There is the International Criminal Court that the United States doesn't submit to its jurisdiction. So I could imagine international proceedings being brought against the United States. There's an Inter-American Court, and already a complaint has been filed in the Inter-American Court for the violation of human rights and the destruction of the boats from Venezuela.
Okay, let's talk a bit about the domestic law, and very specifically the U.S. Supreme Court and its meetings this week. On Monday, took up a case involving so-called independent federal agencies. President Trump wants to fire members of the Federal Trade Commission, very specifically the chairman of the Federal Trade Commission, even though he has a specific term that is set into law by the Congress. It seems to be assumed from the arguments and the comments that the justice has made that this is likely to go the way that Trump wants it to go. What are the implications of that? What does it mean?
Let me put this in a bit of context. In 1935, in Humphrey's Executive versus the United States, the Supreme Court unanimously held that Congress can create federal agencies and provide that the heads of those agencies can be removed only for cause. That case, ironically, also involved a commissioner on the Federal Trade Commission. This has been the law for 90 years, and there's good reason for it. Congress, in exercising its powers, can create agencies that have some degree of independence from the president. It provides some stability in the law. We want the agencies to not just be following partisan will, but instead we'll have agencies that have some Democrat and some Republicans who serve as the commissioners. That's the point of staggered terms that extend beyond the presidency. The person we're talking about here is Rebecca Slaughter. She was initially appointed to the Federal Trade Commission by President Trump. President Biden reappointed her, and she was confirmed by the Senate. Her term continues, but President Trump removed her. President Trump has taken the position that there's a unitary executive branch of government and that he therefore can fire anyone, no matter what the law. He can fire the heads of agencies. He can fire lower level government officials. In fact, his position is that civil service protections that have existed since the 19th century are unconstitutional.
When you say unitary, when the term unitary executive is used, define it, if you will.
Sure. The phrase actually comes from the early years of the Reagan administration, and some young lawyers there, especially John Roberts and Samuel Alito, who are on the Supreme Court. And their view is that the Constitution creates the executive branch of government and gives all of the power within the executive branch to the president. So the president is in charge of the entire executive branch, which here means the president has the authority to fire anyone in the executive branch, and any congressional limit is unconstitutional. And President Trump has expressly invoked this idea of the unitary executive.
What's wrong with that, as opposed to the idea that if you have all of these indicated independent agencies, the president then can't impose his policies, his or her policies, as he wants and needs to do and ought to be able to do since he's elected by everybody?
What's wrong with that is that we have a government with interdependent powers, not entirely independent branches of government. So you have Congress in its desire to make sure that its policies are filled, and the president in the desire that his policies be filled. The way the president gets to do this is to appoint members to the agency who are confirmed by the Senate. But the Congress has some protection in terms of its policies being carried out by saying the commissioners who are there can be removed only for cause. What's interesting is when the unitary executive theory first came to the Supreme Court, it was in 1988. There's a case called Morrison versus Olson, and it involved a federal law that allowed for the appointment of the independent counsel, the person who investigate wrongdoing by the president or high-level executive officials. And the argument was that this is unconstitutional because it limits the ability of the president to remove the person. The independent counsel will be fired only for just cause. The Supreme Court, 7-1, with conservative Chief Justice William Rehnquist writing the opinion, upheld the law and rejected the unitary executive theory. Only Justice Scalia in dissent embraced it. And Chief Justice Rehnquist used language similar to what I've used now, saying, what we have is branches of government that are interdependent, that are meant to check one another. There isn't a unitary executive that's immune from congressional checks and balances.
We're going to go to a chat in a moment, and let's a few moments, I should say, and let our listeners and viewers ask questions. But I just have to ask you one that comes from a retired Superior Court judge, Joe Hilberman. He sent this in. He's also said that you're brilliant, and he sends his holiday best wishes. But he wants to know, is there any chance that Justices Thomas and Alito will not retire during Trump's term, allowing him to place two younger justices with similar philosophies, if you can call that, on the bench? What about that?
Of course, there's no way to know. I don't have any inside information from them. They're allowed to serve until they retire or die, or the impossible event of their being impeached. I think the conventional wisdom is that both Justices Thomas and Alito will retire before the end of the Trump presidency so that he can fill those seats with much younger conservatives. But keep in mind the importance of the November 2026 elections. If the Democrats take the Senate, then I predict they will not confirm anyone President Trump would appoint in the latter 2 years. They will follow the precedent of when President Obama nominated Chief Judge Merrick Garland, and the Senate said they wouldn't consider or even hold hearings about him. So it's possible, if it looks like the Republicans might lose the Senate in November, that Thomas and Alito will retire this summer so the president can nominate and the Republican Senate can confirm. If the Republicans keep the Senate, then I think there's a good chance that Thomas and Alito, if they haven't retired, will do so before the November 2028 presidential elections. But there's no way to know. It's entirely up to them.
Okay. On yesterday, the court took up the case of J.D. Vance versus the Federal Election Commission. This was a case brought by the vice president before he was vice president, having to do with the limits that are set on political parties and how much they can spend in coordination with candidates for federal office. It's sort of a complicated sentence that I just uttered, but that seems to be the case. Explain that, if you will, and what's at stake.
Sure. Here I want to go back to a Supreme Court case from 1976, Buckley versus Vallejo, where the Supreme Court said spending money in election campaigns is speech, and any government regulation of it has to be shown to serve a compelling interest and no other way to achieve it. Since then, the Supreme Court has built on that foundation and said that the government never can regulate expenditures that are made. So somebody had $1 million last year to spend for Donald Trump or Kamala Harris. They could spend a whole $1 million by taking out ads themselves, sponsoring rallies, whatever they wanted. And in Citizens United versus Federal Election Commission, which the Supreme Court in 2010 said corporations have the right to spend unlimited amounts of money in election campaigns to get candidates elected or candidates defeated. But the Supreme Court has also said, well, the government can't limit expenditures. The government can restrict the amount that can be contributed directly to a candidate. So that person with $1 million for Trump or Harris could spend it on their own, but how much they could give directly to a candidate was limited. Well, as part of that law, there's limits on what political parties can spend in coordination with candidates. And the Supreme Court previously upheld that. I think there's no doubt after the oral argument yesterday, the Supreme Court is going to declare that unconstitutional, saying it's restricting the ability to spend money in election campaigns. I think it will strengthen the political parties. I think it will give the political parties more ability to try to have influence in elections because they'll be able to coordinate their expenditures directly with the candidates.
Justice Sotomayor said something to the effect that there won't be any limitations at all anymore.
I think it's right. And I think that that's where we're going. I think we have a conservative majority on the court that believes that spending money in elections is core political speech and that restrictions are unconstitutional. And I think the one remnant that still exists is the ability of the government to limit contributions. And the question is, will the Supreme Court reconsider that in the future? For example, corporations and unions can't contribute money directly to candidates for federal office. Many states don't allow it for state office. I think that's going to come before the court too in the future.
Where does the idea that money equals speech come from?
Well, the first time the Supreme Court ever said it was the case that I mentioned, Buckley versus Vallejo. I always felt that Buckley was wrong and that it took a figurative expression, money talks, too literally. And I think that what we've seen since Buckley, and especially in Citizens United, is the tremendous corrosive effect of money in politics. I think our government has lost a lot of the confidence in the American people it used to have. And some of that is the way the campaign finance system works. In the last election, Elon Musk spent $250 million of his money to get Donald Trump elected. Something is wrong with that, whether it's for a Republican or a Democratic candidate.
Another case having to do with the National Guard. The court is now considering whether the National Guard in Illinois was inappropriately sent to Chicago by the president. And today, a judge in San Francisco said the president had no right to deploy the California National Guard in Los Angeles. How are these cases likely to go? And are they likely to be separate, or could there be different cases decided in different jurisdictions?
There are two different issues. One is, when does the president have the legal authority to federalize a state's guard? The second question is, when does the president have the authority to use the military, including a federalized guard, for domestic law enforcement purposes? The first issue is what the judge ruled on today. What happened here was in June, President Trump federalized the California National Guard to use for purposes in Los Angeles of protecting ICE agents. The federal judge, Charles Breyer, found that this didn't fit within the statutory authority, but the Federal Court of Appeals reversed him. And today he said, even if you accept in June there was enough chaos in Los Angeles to justify it, that doesn't mean that it continue forever. We're now in December. Whatever the crisis was 6 months ago is over. And he said the federalization of the Guard has to end. There is the second issue, though. When can the president use the military for domestic law enforcement? And here there's a specific federal statute. It's the Posse Comitatus Act, adopted in 1878. And it limits the use of the military for domestic law enforcement to very narrow circumstances. In fact, we haven't seen it since 1965 without a specific request of a governor. And there's good reason for a long tradition of not using the military for domestic law enforcement. Soldiers and police officers are trained very differently. Police officers are trained, should be, with regard to restraint and the use of deadly force. That's not how the military is trained. Police officers are trained, or should be, to respect people's rights under the Constitution. That's not how the military is trained. President Trump has used the military in Los Angeles, Portland, Chicago, Washington, D.C. A federal judge in Chicago found that this violated the Posse Comitatus Act. The United States Court of Appeals for the Seventh Circuit upheld that, and that's been pending before the Supreme Court now for about 6 weeks. And I should also mention, Judge Breyer separately found earlier that the use of the troops in Los Angeles was for domestic law enforcement, and that violated the Posse Comitatus Act as well.
So how is the court expected to go on these cases, and will they all be decided the same way?
I don't know is the answer. It's interesting that it's been pending so long in the Supreme Court. On the one hand, the Supreme Court has so far very much been a rubber stamp approving Trump policies. District court judges in federal court have found against the Trump administration in dozens and dozens of cases. For the most part, the Federal Court of Appeals have held that, but with just a few exceptions, the Supreme Court has reversed and ruled in favor of President Trump, almost always 6-3. On the other hand, this is an issue that really strikes at the heart of a constitutional democracy. When can a president use troops for domestic law enforcement? There's something to me quite chilling of thinking of normalizing the military in cities across the country for domestic law enforcement. Yet that's exactly what President Trump says he wants to do.
What about the system that we have whereby we have the Supreme Court that can question what the lower courts do, and even as I understand it, in some cases, determine the facts? It's my understanding that the lower courts are supposed to determine the facts, and the superior courts or the appellate courts are supposed to decide the law.
You're, of course, exactly right. It's well established in the American legal system that the trial courts determine the facts, and an appellate court can overturn that only if it's, quote, clearly erroneous. And yet we have instances where the Supreme Court seems to have completely ignored the fact-finding of the district court. I'll give an example from just last Thursday. There was a case before the Supreme Court. It was called Abbott versus Lulac. A 3-judge federal court in Texas held a 9-day hearing. It produced a 3,000-page record, and it found that creating the 5 additional likely Republican districts in Texas was race discrimination. Yet the Supreme Court 6-3 reversed that and is going to allow the discriminatory maps to go into effect. Justice Kagan wrote a blistering dissent saying this ignores the basic principle of deference to fact-finding by the district court. And in case it matters, the opinion in the district court was written by a judge who had been appointed by President Trump in his first term. So we shouldn't think of this just in ideological terms.
This brings us to no democracy lasts forever, how the Constitution threatens the United States. Are these examples of what you're talking about in that book?
No, the book was completed in the summer of 2023. It was published in August of 2024. I had a lot more to do if they'll let me do a new edition of the book. But the thesis of that book is the choices that were made in drafting the Constitution have come to haunt us now. The Electoral College, which allows for the election of a president who lost the popular vote, it never happened in the 20th century. It's happened twice this century and almost happened two other times. Two senators per state. It was a necessary compromise for the Constitution. But think about during the first 2 years of the Biden presidency, when there were 50 Republican and 50 Democratic senators. The 50 Democratic senators represented 43 million more people than the 50 Republican senators. Or think of life tenure for Supreme Court justices. At the time the Constitution was written, the average age was 36 years old, life expectancy. Now, of course, thankfully, it's much longer. Clarence Thomas was appointed to the Supreme Court in 1991 when he was 43 years old. If he stays on the court until he's 90, the age Justice Stevens retired, he'll be a justice for 47 years. Justice Kagan was 50 when she was confirmed. If she stays till she's 90, that's 40 years. That's too much power in one person's hand for too long a period of time. And I think the Supreme Court has compounded the problems by things we've talked about, allowing partisan gerrymandering, saying that spending of money in election campaigns is pure speech and can't be regulated, striking down key provisions of the Voting Rights Act. And what my book argues is that all of this together has put us in this situation where there really is a crisis facing American democracy.
Well, are you just in disagreement with those decisions, or is there something very basic here that is causing what I gather you regard as too much unsettlement, or if that's the appropriate term?
I think that there is a crisis of democracy is faced by the loss of faith that people have in American government. That when you look at the polls, for example, the Pew Research Institute has been doing polls for a long time about confidence in government. The high watermark actually was 1964, but now we're at a low watermark. Congress, the Supreme Court have their lowest approval ratings ever. Our country is more deeply ideologically polarized than at any time since Reconstruction. And so what I'm talking about is the things that I think caused this. And to take the examples I mentioned, I think that they were mistakes, though necessary ones, when the Constitution was ratified. Take the Electoral College. It makes no sense in a democracy to have a system where the loser of the popular vote can become president. Two senators per state wasn't very troubling in 1787 when the difference between the most populous and the least populous state was about 9-1. Now the difference between Wyoming and California in population is 63-1, but they both have two senators. That doesn't make sense. Life tenure for Supreme Court justices maybe made sense when life expectancy was 36 years. It doesn't today. So I think these are the things that are giving rise to the underlying causes of the problems we see in our democracy now.
What about the pardon power? That's come up for a lot of controversy because of the pardoning of the former president of Honduras, who got 45 years from an American judge after an American jury found him guilty of importing 400 tons of cocaine to the United States.
And I should mention that Emil Bovee, whose name I mentioned before, was the prosecutor in that case.
Yeah.
He then represented Donald Trump. He became a high-level Justice Department official and is now a federal court of appeals judge. I agree with you about the pardon power, and let me put it in context. I think part of the genius of the Constitution is generally requires two branches of government to do anything major. To pass a law, the president and Congress have been involved. To appoint a Supreme Court justice or a cabinet official or ambassador, the president has to appoint and the Senate has to confirm. To prosecute somebody, the executive has to prosecute, but the courts have to convict. To ratify a treaty, president has to negotiate, the Senate has to approve. And I could go through, and I think this is a very elegant way of creating checks and balances. One of the relatively few powers in the Constitution where there's no check or balance is the pardon power. And I think that was a mistake on the part of the framers. And I do think we're seeing it now. It's inexplicable to me why President Trump can simultaneously say, we have to stop drug trafficking by blowing up boats from Venezuela and then give the pardon to the ex-president of Honduras. Or I don't think it got enough of our attention that he pardoned all of those who were responsible for the January 6th insurrection, at the same time firing the federal prosecutors in those cases.
Let me go to the chat session. It's an opportunity for our viewers and listeners to ask questions, and I'll start close to the top. Several people, including Barbara, says, is there anything we can do as citizens to protest about the Supreme Court?
I think there's much we need to do as citizens, not just to protest about the Supreme Court, but to protest what the Trump administration is doing. It's not hyperbole to say that since January 20th, we've seen unprecedented violations of the constitutional laws of the United States, unprecedented efforts to increase the power of the presidency without checks or balances, unprecedented efforts to use power for the sake of retribution. So in terms of what we should do, first, I think it's really important that we be informed. I've heard so many people say that they've stopped reading the news or listening to it because it's too upsetting. We can't afford that now. And when we're informed, we have to help inform others. Second, it's really important that we be involved. There are so many organizations now that are bringing challenges to what the Trump administration is doing. And they are bringing the cases to the lower courts, and they're often winning in the lower courts. And the Supreme Court has only reversed in a handful of those. And so we can talk about what are the organizations like Protect Democracy, Democracy Forward, and ACLU, and Common Cause. And they can use volunteers and they can use financial support. And third, I think we have the obligation to speak up. And there's so many ways that we can do that. Letters to members of Congress and the Senate really make a difference. Opportunity for those who can write letters to the editor and op-eds to have their voice heard there. And rallies matter. The last No Kings rally was 7 million people. What if it was 70 million people? I believe the Supreme Court would pay attention to that. I believe Congress would. And of course, most of all, we have to be involved and express ourselves by voting. This coming year's elections are going to be so important.
Ruth wants to know, given that SCOTUS, the Supreme Court of the United States, is rubber stamping everything that Trump is doing, why should we believe they wouldn't allow him to do an end run around Congress and unilaterally declare war or engage in piracy?
The Supreme Court may very well rule in favor of President Trump about that. There is a long history of great deference to the president when there's a claim of national security. There is a great deference to the president when it involves international affairs. And the court has been very deferential to the president in the use of troops in foreign countries. So I think a successful challenge to what President Trump is doing with regard to Venezuela is going to be hard to win in the courts. But I still think it's so important that every effort be done to hold him accountable.
Can you explain, with regard to what we said earlier, the international court and how it works? Is there any reason to believe that it'll ever be able to hold people in this administration accountable?
There's not just one international court. There is, for example, an Inter-American court, and a complaint has already been filed there. There is an international criminal court. There is an international court at The Hague. And I expect that there'll be efforts to try to hold President Trump and his administration accountable there. How successful they'll be is a different question. And the reason is that they generally don't have much ability to enforce their rulings. There may be a rhetorical benefit to going to those courts in their rulings, but the practical legal effect is much more uncertain.
Marion wants to know, didn't the United States attack sites in Iran without a declaration of war? How is that different from what they're now doing at sea near Venezuela?
I think it's a great question. I mean, there is at least the possibility that maybe the authorization for the use of military force adopted after 9/11 could provide some justification for what was going on in the Middle East. I think it's a stretch, but the internet authorization of use of military force has never been repealed. But you're right in terms of that strike, or I can give you many other examples under both Democratic and Republican presidents. Think of President Obama's bombing of Libya. There was no authorization for the use of military force there. Or go back to Lyndon Johnson and his invading the Dominican Republic. There was no authorization for the use of military force there. I think the problem with this is it so departs from what our constitutional structure was supposed to be. We're supposed to have checks and balances. The Congress has the power to declare war, and if they do, the president wages war. And Congress doesn't have to pass a formal declaration of war. There was the Gulf of Tonkin resolution that authorized the use of military force to repel North Vietnamese aggression. I've mentioned the authorization for the use of military force, but our tradition has now been a tremendous accretion of power to the president to be able to use troops in foreign countries.
But the Congress could take action in these instances.
Congress could. One thing that Congress could do is pass a law that says no federal funds can be used for particular purposes. You'll remember that they did that in the early 1970s to say no federal funds could be used for the bombing of Cambodia, or in the 1980s during the Reagan administration, no federal funds could be used to fund the Contras who are fighting in Nicaragua. And so Congress has the spending power and can do that. The difficulty, of course, is that any bill that's passed by Congress could be vetoed by the president, and then it would take a two-thirds vote of both houses of Congress to overcome that. There is also a federal statute called the War Powers Resolution that says that the president can use troops in a foreign country in a war situation for only 60 days without congressional authorization. The question is, will any court be willing to enforce the War Powers Resolution?
A similar kind of thing comes up perhaps in answer to this question. There seems to be no remedy against Trump's subordinates who act illegally. Is it possible to take some of them to courts in civil court where there are no pardons and seek huge financial penalties?
I think it's really important that while the president has absolute immunity from criminal prosecution for official acts, those who are subordinate to the president can be criminally prosecuted. In fact, even if they're carrying out an order of the president, if they violate the law, they can be criminally prosecuted. The absolute immunity of the president from criminal prosecution is only as to the president, not to those who are carrying out his policies or even following his orders. With regard to civil liability, the president also has absolute immunity from civil liability for official acts, but those who are carrying out the president's policies, those subordinate, don't have absolute immunity, and they can be civilly sued for money damages.
A couple of people have asked these historical questions. Are you keeping track of how many times this Supreme Court has overturned precedent? I don't know what this court would mean because the court changes over time, but I think we pretty much know that it means the 6-3 lineup that we have now. How does this compare to other Supreme Courts? This listener wants to know. It's Craig Stevens.
This Supreme Court is overturning precedent at about the same rate, or maybe even a bit less than predecessor Supreme Courts. But the difficulty with that count is not all cases are equal with regard to their impact in the law or their impact on people's lives. Take the Supreme Court overruling Roe versus Wade. That was an enormously important decision for society, and it can't be equated to the Supreme Court overruling a precedent in a much more limited area of law.
What about the case now pending before the U.S. Supreme Court having to do with the birthright citizenship? Is there a threat that a majority might interpret the 14th Amendment provision on that issue in a way to redefine that provision to end birthright citizenship? How could that be implemented, and what would its impact on voter eligibility be in 2026 or 2028?
Let me provide a little bit of background. When the United States began in 1787, it followed English law that everyone born in the country was a citizen of the country. This was the law until the Supreme Court tragically departed from it in 1857 in Dred Scott versus Sanford. There, the Supreme Court held that enslaved individuals are not United States citizens, even if born in this country. When a decade later the 14th Amendment was drafted and ratified, 1868, the very first sentence of Section 1 says that all persons born or naturalized in the United States and within the jurisdiction thereof are citizens of the United States and the state wherein they reside. In 1898, in United States versus Wong Kim Ark, the Supreme Court interpreted that sentence. It was a case that arose in San Francisco. And the Supreme Court said, the first sentence, 14th Amendment means everyone born in the country is a United States citizen, regardless of immigration status, their parents. And the court said the phrase within the jurisdiction thereof just means if there was an invading army and a soldier had a baby, or if there's a foreign diplomat who had a baby, those children would not be United States citizens. And ever since, it's always been the law that everyone born in this country is a United States citizen. President Trump, in an executive order on January 20th, changed that. And so essentially, only those who are born to citizens or those with green cards are United States citizens. So imagine that we have a student at Berkeley who's not a citizen of the United States, but lawfully in the country and has a baby. Under President Trump's executive order, that baby would not be a United States citizen. I think here the Supreme Court, though it's generally been deferential to President Trump, is likely to rule against him. This is a court that wants to focus on history, the text of the Constitution, tradition, and all of these indicate that everyone born in the country should be a United States citizen.
We have a question about stare decisis, the idea of respecting previous determinations about what the law is. This person thinks that that's being thrown out the window. How does the court justify eroding the checks and balances contemplated by the founders and by the Constitution?
One of the ways that the Supreme Court is constrained is it's supposed to follow precedent. Of course, the difficulty is there's long books and articles written about stare decisis, and they always come to the same conclusion. Precedent should be followed except when it should be overruled. And that's right, of course, because we all believe that there are times when precedent has to be overruled. It was imperative that Plessy versus Ferguson be overruled in Brown versus Education, but also precedent matters for the sake of stability. I think the reality is, whether it would be a liberal or conservative majority, they're going to overrule the precedents that they strongly disagree with. And this is where we started the conversation tonight. I think the Supreme Court in Trump versus Slaughter is going to overrule Humphrey's executor and say that the president can fire any agency heads and federal statutes limiting that are unconstitutional. It's a 90-year-old precedent. It's been followed without exception, but I think now we just have a majority that disagrees with it.
A lot of people have asked, is there any type of Supreme Court reform that you would particularly support? And I would add anyone that's likely to be implemented.
I would favor term limits for Supreme Court justices, and I think it's plausible if it's done prospectively not to apply to anyone on the current court, only to kick in when there's a vacancy in those seats. There's a Gallup poll that shows 77% of the American people favor term limits for Supreme Court justices. We tend to forget that in 2016, there were three Republican candidates, Rick Perry, Mike Huckabee, and Ben Carson, who endorsed 18-year term limits for Supreme Court justices. In some of this, we said that life expectancy is a lot longer now. Let me take as an example Justice Amy Coney Barrett. She was 48 when she was confirmed for the court in 2020. If she stays until she's 87, the age Justice Ginsburg passed away, Barrett will be a justice into the year 2059. Also, too much depends on the accent of history of when there's vacancies. President Trump had 3 picks for the Supreme Court in his first term, but the prior 3 Democratic presidents, Jimmy Carter, Bill Clinton, Barack Obama, served a combined 20 years in the White House and only picked 4 justices. Richard Nixon picked 4 justices in 2 years. Jimmy Carter picked no justices in 4 years. So I think 18-year non-renewable term solves this. And I do think it's plausible if it doesn't apply to the current sitting justices.
Jeff wants to know about campaign contributions. Makes the point that if money equals speech, some people have more power than others do to influence the vote. Why hasn't that been taken into consideration by the court?
It has been taken into consideration. Initially, the Supreme Court said that there could be limits on expenditures as well as contributions as a way of leveling the playing field. In a case called Austin versus Michigan Chamber of Commerce, in an opinion by Justice Thurgood Marshall, the Supreme Court, said that the government could limit expenditures just for that. When the Bipartisan Campaign Finance Reform Act was before the Supreme Court, that, among other things, limited the ability of corporations to spend money. The Supreme Court, in a joint opinion of Justice O'Connor and Justice Stevens, said the equalizing of the playing field, that preventing some voices from drowning out others, justified this. But then in Citizens United, the Supreme Court overruled that case and rejected the idea that the government should be able to regulate spending so as to prevent some voices from drowning out others.
Ellen asks, do you think President Trump will declare martial law during the 2026 election so he can distribute troops to intimidate voters and force voters to shy away from the polls?
There is no such thing as martial law under the United States Constitution or under federal statutes. But I do have the concern that one of the things that the president could do, if he can use troops for domestic purposes, is station troops near polling places to intimidate people in certain areas from voting. Or I worry that they would station ICE agents near the polls in predominantly Latino neighborhoods to discourage people who are citizens and lawfully have the right to vote from coming out and voting. I think that that's something we should be afraid of.
Ruth wants to ask about the Texas redistricting case. Was that just a rubber stamp of Trump and MAGA/GOP? Seems like it's dangerous since now mid-decade redistricting could become rampant in both the blue and red states. It seems to me it already has. What about that issue and this question of race and when it applies or doesn't apply to decisions?
Let me start with in 2019, in Rucho versus Common Cause, the Supreme Court said federal courts cannot hear challenges to partisan gerrymandering. I think it was a terrible decision. It was 5-4 split along ideological lines. But there still is the ability to challenge districting if it's motivated by race. And the three-judge court in Texas found that, and it was a 160-page opinion, that the Texas legislature would use race in drawing districts. The Supreme Court stayed that last Thursday, and I thought that the Supreme Court's reasoning was very disturbing. One of the things that the Supreme Court said explicitly was that the only way the court could invalidate this map is if they could show another way of creating 5 likely Republican districts that wasn't race discrimination. Well, why should that be the burden of the district court? If this is race discrimination, why isn't it invalid? And also very disturbing, the Supreme Court said this is too close to the election, so federal courts shouldn't get involved. Well, Governor Abbott signed the maps for Texas on October 25th of this year. A lawsuit was immediately filed. As I mentioned, the federal court held a 9-day hearing. It released a 160-page opinion, and the Supreme Court says, no, too close to the election, therefore the federal court can't get involved at all. What Justice Kagan says, rightly so in her dissent, is this then means that a legislature can do the most unconstitutional things with regard to voting or districting, and if it's close before the election, the federal court can't do anything. And close before the election here is months, not days.
Excuse me, for shifting through the Linda wants to know, what does a Supreme Court justice have to do to be impeached? Who has the power to impeach a Supreme Court justice?
It takes a majority vote in the House of Representatives and a 2/3 vote in the Senate. It's the same as it would be to impeach a president or any federal government official.
So anybody in the Congress, any Congress member could, in fact, initiate a resolution to do that?
They could initiate a resolution to do it, but it would take a majority vote in the House and a 2/3 vote in the Senate. What worries me much more is that there have now been, I think, 6 instances of impeachment resolutions introduced in the House by Republican members of the Congress against judges that ruled against the Trump administration. Now, I don't think that these judges are going to actually be impeached. I don't think there's going to be a majority of the House, two-thirds of the Senate. But I do think it's about trying to intimidate judges to not rule against the president.
Uh, Somebody wants to know, do you think there's any way that President Trump could seek a third term in office?
No, there is no way so long as we're under our current Constitution. The 22nd Amendment is explicit that no one can be elected twice to the office of president. Some people have said, well, could it be that J.D. Vance would run for president, Donald Trump would run for vice president, and then Vance would retire and let Trump become president? The 12th Amendment says that the only people who can run for president or vice president are those who would be eligible to serve as president. So it would really take something apocalyptic, the end of our Constitution, for Donald Trump to be able to have a third term in office.
Uh, what what do you think have been the two worst Supreme Court decisions since the existence of the court?
There's a lot of them. I mentioned Dred Scott versus Sanford, which said that enslaved individuals were not citizens even born in the country, struck down the Missouri Compromise. Plessy versus Ferguson, that upheld separate but equal and led to the Jim Crow laws and apartheid for much of the country until well into the 20th century. Korematsu versus United States, where the Supreme Court upheld the evacuation, the internment of Japanese Americans. In more recent times, I think Citizens United is a terrible decision. I think that Trump versus the United States, giving the president absolute immunity from criminal liability, is wrong. I've often spoken of, I think there should be a hall of shame of Supreme Court decisions. And I think that the ones that I've mentioned, and there's others, belong in that hall of shame.
We have a couple of minutes left, and it is a tradition on this program that we ask the guest, whoever it is, to try to say something positive, try to say something encouraging about life and the way things are going. We've talked a lot about, there's been a lot of criticism on this program. So how do you, or what do you have to say in that context?
It's, I think, exactly the right question. I will say, as I answer it, that I'm more frightened now and more frightened than I ever imagined I could be for the future of democracy. I do think that we've seen challenges to the Constitution unlike anything this country has experienced. What gives me hope is this isn't the first time the country has faced constitutional challenges, and we've gotten through them before. In fact, what gives me hope is that when I look at the sweep of American history, there's been tremendous advances of freedom and equality. If you think of what the country was like in that regard in 1787, or even when I was born in 1953, we have so much more in the way of equality and freedom, though there's still a long way to go. I think the late Dr. Martin Luther King Jr. got it right when he said, the arc of the moral universe is long and it bends towards justice. And the other thing that gives me hope, I have to say in all sincerity, is my students who I interact with every day. They're so idealistic. They're so committed to using law to make society better. That gives me hope for the future.
Do you think that they might take on, you said, talked about challenges to the Constitution. Your book says the Constitution itself is a challenge. Do you think these students are taking that kind of thing seriously? Are they likely to try to address that kind of an issue as time goes on?
Right now, there's the urgency of challenging the unconstitutional and illegal acts of the Trump administration. I think in the longer term, progressives are going to create their own Project 2029, try to blueprint, much like the Heritage Foundation Project 2025 did. And I think we do need to take on the structural problems in the Constitution that give rise to where we are now. And I'm hopeful that my students will be part of taking that on.
So you do have hope.
I do. Um, and, I said to the students this past spring at commencement at Berkeley Law, I said, we really have just two choices. Either we give up or we fight harder, which means we really only have one choice. We have to fight harder and better than we ever have before to protect the Constitution, to advance liberty, to further equality.
Erwin Chemerinsky, it's always a privilege to talk to you, and thank you so much for being back on America at a Crossroads. It's just great to have
Truly
you.
my privilege to talk with you and to be part of it. Thank you for having me.
This is this next week will be the last program for America at a Crossroads. There's going to be a 2-week hiatus for Hanukkah and Christmas and New Year's. And next week, it's going to be the former U.S. Ambassador to Russia and Stanford Professor of Political Science, former Ambassador Michael McFaul, in conversation with Larry Diamond, who's also been at who's also at Stanford. Autocrats versus Democrats is his book, The New Global Disorder. That's going to be a great program next week. Be sure to check it out, and then have a couple of weeks of rest, and we'll be back in January. Thanks again for being with us today.